Good day to all of the speakers. Welcome back to another episode of UM Law Podcast and also Keeping Up with the Constitution. I'm Rou Xin and I am the host for today's episode. And I have here with me Professor Dr. Jason Chuah and the Dean of the Faculty of Law of Universiti Malaya. Professor was one of the holder of Cambridge Commonwealth Test Award, having a PhD that focuses on the influence of the need of commercial certainty on the judicial development of commercial and maritime law. So the topic for today's episode is regarding the Sabah and Philippines dispute, specifically on the Sulu arbitration issue. So the first question I would like to ask Professor is, could you start by giving us, the listeners, a brief overview of Sulu arbitration issue and its historical background?
Good afternoon, Rou Xin. It gives me a lot of pleasure to be doing this podcast for the faculty and for the Consti team or the Consti Club. And yes, certainly I'll be very happy to talk about the Sulu arbitration. Obviously, this is an issue that has vexed and has created a great disquietude amongst many Malaysians who feel very strongly about our sovereignty and about our territorial supremacy, I think. So there is nothing brief with history, unfortunately, and but I shall do my very best to give you a bit of an overview of where the Sulu arbitration problem first arose, and then we will move forward to more recent times to see what actually transpired in an international plane, and then of course perhaps to map out some lessons for the future. So Sabah, of course, once upon a time used to be called North Borneo, but before it was North Borneo, a large part of what we know to be the current boundaries of Sabah, about 40 to 50% of what we know to be Sabah, was part of what was the Sultanate of Sulu. And the Sultanate of Sulu, of course, is no longer in existence. It had fallen subsequently to the Spanish, and then, of course, as far as the Filipino history is concerned, the Philippines then came under the rule of the Spanish and subsequently the Americans. So as far as this part of the territory is concerned, the area in dispute, that is to say, this sort of northeastern part of Sabah, was leased by the Sultan of Sulu and their representatives to a person called Baron von Overbeck, who was an Austrian national, and he was very friendly with certain individuals who were traders, and notably there was a man called Alfred Dent who was with the British North Borneo Company. Now, if you have studied anything about Malaysia legal history, you will remember that as far as West Malaysia or the peninsula is concerned, we've had the influence of the East India Company here in Malaya in those days. But in Sabah Sarawak, especially in Sabah, the British company that was very active there was called the British North Borneo Company. Now, this lease or cession is problematic because the lease was actually expressed in Jawi Malay, and it was done in 1878. And the word used was pajakan. So this piece of land was pajakan to Baron von Overbeck, and of course, subsequently, if you like, the British North Borneo Company. Now, this agreement, of course, this document is very problematic because if you consider the word pajak to mean a lease, then we know that a lease is not is only a case of giving a property right. You're not giving away your land. It's just that somebody can use it, and then they have to pay certain, certain sums of money to use your piece of land, and they have got to comply with the terms and conditions of your lease. A little like you, if you're renting, a room from the residential college, right? So, but if the word pajak does not mean a lease, but if it means cession, that means territory is ceded, which means given away. So this is giving away. It's not a lease. So you lease something, you don't give it away. But giving away or cession means that the entire property, the entire land is given away. So this was the interpretation adopted by the British, which of course subsequently was also adopted by the Malaysian government. So the Malaysian position is that pajakan does not mean lease, it means cession, which means giving away. And of course, if it's given away, then this territory, was given away to Baron von Overbeck, which was subsequently given away to the British North Borneo Company. And when the British North Borneo Company was taken over by the British Crown, it was given to the British Crown. And of course, when Sabah was asked to decide whether they wanted to be part of Malaysia in 1963, and they exercised their right of self-determination to do so. What happened then was that this piece of land then passed on to Malaysia. So this is the Malaysian position. So this is the historical context. But of course, when it comes to this pajakan, if you like, there was a price to be paid, and it was $5,000. And so the question was, back in 1963, our then Prime Minister, Tunku Abdul Rahman, consulted on the issue and decided that we will pay the so-called heirs of the Sultanate of Sulu this $5,000. So we continued to pay that, which of course at that time was Malaysian dollars, and then subsequently it became the ringgit Malaysia. So this money was paid on a continual basis every year until 2013. Because something happened in 2013. In 2013, you may remember that certain terrorists, if you like, or certain groups of individuals claiming to have links with the Sultanate of Sulu, which of course does not exist anymore, attacked Lahad Datu. And as you will remember, it was quite a tragic incident with people dying, people getting hurt. And the Malaysian government, of course, decided that because of this incursion into Malaysian territory by these, assault teams, the government decided that we will not pay the 5,000 ringgit as consideration for the cession of that land or for the lease of that land, depending on whether you see it as a lease or a cession. But of course, as a result of that, these monies were stopped, and the next thing was that some lawyers went and met up with some of these successors of the Sulu Sultanate. That means that, descendant after descendant after descendant, and say, look, the money has been stopped, we can bring this matter to arbitration for you, and if you win, we will take a cut. We will take our cut of the winnings, And so, of course, the reason then this went to arbitration was because that 1878 document I was telling you about actually contained an arbitration clause. The clause refers to the fact that if there were any disputes arising out of this pajakan, they have to be resolved or referred to Her Britannic Majesty's Consul General for Borneo. Now, this is a position that no longer exists, and but the lawyers argued that there is an arbitration clause, which meant that these individuals who had their 5,000 ringgit stopped could actually sue or bring proceedings against the Malaysian government in an arbitration. So arbitration process commenced in Spain. But of course, at the time, Malaysia decided that, well, this is all very frivolous and this is vexatious and we shall have nothing to do with it. So the Malaysian government did not take part in the arbitration. Now, of course, if we don't take part in the arbitration can still go on. And as a result of the arbitral process continuing, the arbitrator decided against Malaysia and awarded a very, very, very large award against Malaysia. Probably one of the world's largest arbitral award ever to be awarded. And so, of course, this was quite, if you like, quite scary because, once there is an award out there, that means they can enforce that award against the country. And it means that any asset Malaysia has across the globe could be vulnerable to seizure and execution orders by tribunals and courts all over the world. So that is the context of the setup, so to say. But the Filipino story I would perhaps tell you later on. But the very sort of brief assertion one could make was that the Filipino government has always stood by the claim that because they succeeded the land from the Spanish, then the Americans, they then also succeeded to the land which the Sulu Sultanate had claimed to have given to Malaysia, because they take the line that this was a lease, not a giving away of territory. So if it's a lease, then we can have it back. So that is essentially the Filipino claim. But there was an international declaration in 1966, thereabout 63, called the Manila Accord. And in this Manila Accord, they decided that the Filipino government would recognize the self-determination rights of Sabahans, but they also make it clear that, whilst we respect Sabahan people's right to self-determination, it would not prejudice their territorial claims. So that's a very long story. Hopefully I've been able to capture it in the last 2 or 3 minutes.
Thank you so much, Professor. That is a very informative session about the historical background of the Sulu arbitration issue. So, as a maritime law expert, I would like to ask how does maritime law actually intersect with this Sulu arbitration issue? Can you provide some of the real-time examples on the recent cases for our listeners to understand more on this topic?
Yeah, sure. Thank you. It's a very good question, but it's also a very difficult question. But of course, being a professor, one rather likes difficult questions. I don't think students like difficult questions, but we're not in the same game. But anyway, so this question about maritime law is an interesting one because actually with the Sulu arbitration, there was very little maritime about it. There was very little maritime angle to the arbitration. As I said, it was very much over land. But of course, as you know, land is not just physical land. It's also land which is covered by water. So the territorial sea is an issue. Now, the two sort of scenario intersects because when the British North Borneo Company took over this part of land in what is today Sabah from the Sultanate of Sulu, that 1878 document refers to 3 maritime leagues. Now, 3 maritime leagues was referred to as defining the territory in question. So this means that it is the physical land which was taken, but also 3 maritime leagues extending from the shore. Now, 1 maritime league is about 3 nautical miles. So if you count that, that would be 3 plus 3 plus 3. So that would be about 9 odd nautical miles. And 9 nautical miles is roughly about 11 to 12 ordinary miles. Yeah, I don't do kilometers, unfortunately. I'm very old school. Now, that was under the 1878 treaty or agreement. But of course, as we know, the British North Borneo Company was subsequently taken over by the British Crown, by the British government. And of course, then North Borneo was ruled by Britain directly, no longer via this British North Borneo Company. And in 1954, a piece of legislation was passed, and I've actually got it here, which is quite an interesting one. You can have a look at it.
Thank you.
1954 North Borneo Alteration of Boundaries Order in Council, passed in England, and signed off at Buckingham Palace by the Queen of England then. Now, this Alteration of Boundaries Order in Council provides that the territory of North Borneo, remembering that North Borneo is Sabah, the territory of North Borneo would have a territorial sea, but also the continental shelf. And that definition means that the territorial waters or the boundaries of Sabah would actually extend 200 miles into the sea. Now, that's a very big tract of land, yeah? Now, this was what happened in 1954. Now, as we all know, 1954 was at least 9 or 8 years before Malaysia Day in 1963. Now, of course, after the Sabahans have exercised their right of self-determination to become part of Malaysia, the federal constitution was made following the Malaysia Agreement of 1963. And based on the Malaysia Agreement of 1963, Article 2 provides in the federal constitution that if the federal government were to alter the boundaries of a state like Sabah, they would need to have the consent of Sabah. Okay, so if you want to change the boundaries, you have to get the consent of the state. Now, if no alteration had been made, then Article 1.3 of the Federal Constitution asserts that the territories are defined based on the territory or the boundaries that those states had immediately prior to Malaysia Day. Now, so immediately prior to Malaysia Day is the Sabah with the 200-mile territorial waters. So that was essentially, if you look at the federal constitution and, of course, the 1954 legislation, you would say that Sabah would have 200 miles of the continental shelf as part of its boundaries. Now, this is, of course, all quite... it's actually quite stark, because what happened in literally just about 6 years later, there were racial riots in Peninsular Malaysia largely, and emergency law was passed. Now, emergency law was passed, and you would assume that when you pass emergency law, it will deal with special powers of arrest, that sort of thing. And of course it did. But the emergency legislation also provided for a change in the territorial sea of Malaysia. Now, the legislation says that for states, every state, from Sabah, Sarawak, all the way to Pulau Pinang, Selangor, every state will only have inland waters of 3 miles.
Oh.
Okay. Now you can imagine if you were a Sabahan who knows your rights, you would think I had 200 miles of sea to, mine oil and minerals and gas and everything else from, and suddenly it's all gone down to 3 miles, right? But of course, in 1969, the Sabahans didn't say anything because perhaps, it was a case of not actually knowing what the law says. Now, of course, the federal government in this piece of legislation also say that inland waters, 3 miles for the states, 12 miles of territorial sea for the federal government. Okay? So then in 1982, Malaysia signed the United Nations Convention on the Law of the Sea, and in 1996 that convention was ratified. But the interesting thing about this convention is that it provides for states to have 12-mile zones, 12-mile territorial sea, which of course is fine because that's what Malaysia has claimed as federal government, correct?
Yeah.
Okay. So fast forward to the 21st century, in 2012, it was felt by the federal government that we cannot just live with emergency law because the emergency is long over. So we need to have a new piece of legislation. And the new piece of legislation is called the Territorial Sea Act. And in this Territorial Sea Act, the outrageous thing as far as some people were concerned was the fact that it provided for keeping the position under the emergency legislation. That is to say, states 3 miles of inland waters, the federal government will take 12 miles. Now, of course, this is consistent with international law, but of course, it's not consistent with, some would argue, the rights that Sabahans have under the federal constitution, because you've changed the 200 miles to 3 miles with no consent.
Yeah.
So this was one of the issues that is plaguing us till today.
Wow, that was a lot of information that I've been receiving, and it's really helpful. Thank you so much, Professor. So the next question I would like to ask is that how has this arbitration affected Malaysia's diplomatic relations with the Philippines and the other countries in the region? So could this case actually set a precedent for similar maritime or territorial disputes in the future?
No, because actually, number one, this arbitration award was found to be defective and cannot be enforced because the arbitrator had no jurisdiction, and this was confirmed by the French Court of Appeal. And the second thing, of course, is that this arbitration was not really about the Filipino-Malaysia claim over Sabah. It was about the rights of the successors to the Sulu Sultanate, as to whether they're entitled to their 5,000 ringgit, which of course, if you had not been paying since 2013, and of course you then have to take on board, inflation and also the value of the land and so on, whether they were entitled to a larger compensation than just the 5,000 ringgit. So the case was not about the territorial dispute between Malaysia and the Philippines. In fact, the Filipinos have always asserted that the joint declaration, as I referred to, that was made in 1966, to say that we respect the self-determination of Sabahans, but we reserve our rights over territory. But they've not taken action over that.
Oh, okay. So for our listeners who might be not familiar with the arbitration process, could you walk us through on how the international arbitration is conducted especially in such a complex case like the Sulu arbitration issue involving the historical claims and also the sovereign status. Yeah.
I'm sure that we could talk about this for several hours. Essentially, you're asking me about arbitration law and process, and that's a big subject. But just to keep it very briefly, in order for us to have an arbitration, there must first be an arbitration agreement. We saw this arbitration agreement in the 1878 agreement. Whether it is a valid arbitration agreement is, of course, another matter. Then arbitrators are then appointed, and in the case of the Malaysia versus the Sulu heirs, Malaysia did not appoint any arbitrators because I said to you, Malaysia did not want to take part. So if you don't take part and the other side appoints an arbitrator, that arbitrator has the power to make the decision. And then an award was given, and then once an award is given, your only option is to challenge the award. And unfortunately, because this was an international arbitration award, it's very difficult to challenge. In order to challenge, you have to prove the grounds which have been stated in an article called Article 5(1) of the New York Convention, and the grounds are very limited. But one ground which Malaysia succeeded on in France was the fact that there was no jurisdiction conferred by the arbitration clause. For example, because the arbitration clause is defective, or perhaps the arbitration subject matter did not fall within the arbitration clause. Now, of course, the last thing I should say about the Malaysia Sulu heirs arbitration award was the fact that this arbitration was funded by third-party litigation funders, which means that there was a private company out there that was paying the lawyers to represent the Sulu heirs. The reason they do that is they see this as a financial investment, because if an award is given against Malaysia, then they take a big cut of the winnings. And of course, this has raised an issue about whether in arbitrations such as these involving states, whether, and especially states whereby the claims are so big, whether we should allow for third-party arbitration funding at all. So that's the big policy debate going on at the moment.
All right. Thank you, Professor. So for the last question for today's episode, what are the specific steps and experience would you recommend for the young legal professionals who are keen to pursue a career in maritime law and also international arbitration? So are there particular skills or areas to study or they should focus on?
Well, I mean, ideally, of course, they should have an interest in maritime law and international law. I think it's understanding that I mean, the beauty of maritime law is that it does not exist in a vacuum. It exists in this very globalized, very highly networked world that we live in. So somebody who wants to work in this field needs to be quite aware of international politics, and needs to be aware of history. They need to be aware of commercial imperatives. They need to be aware of institutions at an international level. So you have to have a very strong international mindset, number one. Of course, number two, in terms of maritime law, there are many, many different opportunities within maritime law. You don't have to work in a very public law-focused kind of area such as this. You could do something very commercial, for example, such as shipping law, such as sale of goods, such as trade finance and marine insurance. Those things are essentially the bread and butter of what maritime or shipping lawyers do. But of course, I mean, it's very hard to avoid understanding or learning about the law of the sea. Therefore, those who work in maritime law would normally be proficient both in the commercial aspects as well as the public law aspects. But that's just about what law schools can provide students who are interested in this. Of course, as I said, it always helps if they are interested to seek out opportunities for internships, placements, with firms and with organizations, NGOs, and so on, who have an interest in this particular field. And of course, I mean, subsequently, if they're looking for a position after graduation, working for the legal services at the AG's chambers, for example, or Wisma Putra, for example, will always give you first-hand experience into this. Of course, I mustn't forget to mention my friends in Jabatan Laut, which is not a bad place to work as well. And you come across the kind of day-to-day regulatory challenges, such as how do you deal with piracy? How do you deal with oil pollution? How do you deal with a ship collision at sea, or illegal ship transfers of oil and all that sort of thing. Very, very exciting fields. But as I say, there is the money-making side of maritime law, which is very commercialized. And then, of course, you've got the governmental related aspects of it, which, of course, would not be so lucrative. But, of course, very rewarding indeed.
Oh, thank you so much, Professor, for such an insightful session today. I think I've learned a lot, and I hope that all of the listeners have learned a lot, like me today too. So thank you so much, Professor, for your time. And I think that will be the end of our episode for today. So let's see you in the next episode. And thank you, Professor Doctor, once again.
Thank you so much. It's been a pleasure to be involved. And I do hope that the little podcast had not been too overwhelming, because there's a lot of information there, but we're always very happy to talk to students who are genuinely interested in the subject. So I wish you all the very best, and congratulations on an excellent series of podcasts.
All right, thank you so much.